Hey viewers, welcome to this episode presentation. The other time we talked about the schools of thought as founded within the social foundations and perspective of law. That was the first school of thought, the naturalist school of thought, initiated by St. Thomas Aquinas. Today, rather, we want to talk about the school of thought number 2, legal positivism, that emerged sometime during the Enlightenment period, around 18th, 19th century, and was explored by English positive jurists. We say English positivist jurists because this is the brand of thinkers that had already been influenced by empirical sciences and by David Hume, that based his thinking in the truth being based on what we experience, what we can experience through our senses. Again, the same David Hume, a Scottish philosopher during that time, is the one who talked and elaborated on the area known as common sense. However, I submit that positivism is about physical sciences, physical evidence, what we can verify, what we can touch, and in this case, evidence explains more about the legal positivism and the theory of this kind of science. Now, the scientific knowledge known as positivism engulfed the legal knowledge, submitting that law joined the cognitive sciences and is one of the empirical sciences that are subjected to university studies and debates and research and scrutiny. The same discourse enables us today to look at the definition of the law within the positive sciences or the legal positivism school of thought. This is nobody other than the 19th century one known as Jeremy Bentham. Professor Bentham taught John Austin, who became law lecturer at the Law School of London, who defined the law as a chain of commands. Well, a chain of commands coming from uncommanded sovereignty, of which people are expected to obey, and the failure to obey is followed with punishment. And people obey the law because of fear of punishment, according to this definition of John Austin. John Austin and similar group of scholars in the positivism school of thought believe that law must emanate from a sovereign authority. Then the law must again be enacted following certain well-established and agreed procedures. In Kenya, in Parliament, we talk of standing orders. Standing orders are procedures, procedural law that are necessary and required for any law to be valid. Well, the bills pass through certain rigorous procedures that are uniformly accepted and well explained in the standing order. In that case, law doesn't require any other explanation other than itself. This is law as it is, not law as it ought to be. This school opposes the naturalist theory school of thought that linked law to morality, linked law to some religious beliefs. It is pure science of law that sees law in terms of the posited law. And this is found in the Acts of Parliament, the statutory law, and the book of law, the written law. So what is written is what is law, and what is accepted by Parliament and signed into law by, or assented into law by the executive and interpreted as law by the judiciary is what is law. Beyond that, the legal positivists tend not to accept. Well, this one comes with pros and cons, and some problematic areas of concern, of course, in the sense that positivists cannot tell whether the law is good or bad, because that kind of moral analysis does not come in. They can only talk of law being valid because it was validly enacted into law, or being invalid because it was invalidly enacted into law. But the same scientists fail to explain to us whether the law is good or bad. This one comes again from the biggest challenge of the Nazi government, or the Third Reich regime, during the Second World War. Whatever the Nazi government did was within the law of Parliament, the Act of Parliament. And under the leadership of Adolfus Hitler, it is clear that the commanders, the military, the police officers, or the government officers, state officers, acted within enacted law. But the moral question, which is a challenge, can we charge them in the court of law, not of violating the written law or posited law, but by violating the law that is beyond the Parliament, and that is human rights, the war crimes, the crimes against humanity. Now, this one has brought a lot of questions about adhering to the written law in terms of Acts of Parliament as the only law that one should address and talk about as from the positivist perspective. There are many other challenges facing this school of thought, such as the question of interpretation, because when we talk of interpretation, which is done by the court, it is a question of judge looking into other areas while interpreting the law other than the law itself. So in that case, the belief that law should be positive science, and that is what it is out of question when we talk about the interpretation. The interpretation of the law is done by the judiciary, but as well, the legislature also interprets the law while amending the law, or while revising a piece of legislation, or repealing the law, or abrogating the law. They do the interpretation. The same interpretation is done by the executive. The executive does a lot of interpretation of policies, regulations, and the law as well. So in this case, the question of interpretation requires some dosage of morality to see whether that piece of legislation is good or bad, or whether maybe some provisions within the law are not in line with what is expected in the society. So there is a clear nexus between the law and morality. There's a clear nexus between the law and the social phenomenon in which the law is operating. We also believe and argue that law does not exist in a vacuum. Law operates and exists in politically charged environment. Now, the argumentation put forward by moralists and positivists is that can we address issues of law without looking beyond the law, without making references to morality? Can we think of the law together with morality? Or can we look at the law without elements of positive stances? These argumentations have been addressed in depth by so many legal scholars and lecturers, professors, such as H.L.A. Hart, Lon Fuller, John Finnis, Ronald Dworkin, and many other new brand of legal philosophers, such as John Rawls in his book known as A Theory of Justice. We have seen so much being debated out there that make us have a broader understanding of the law other than narrow understanding of the law. And that is the purpose why we talk about the schools of thought, because they help us to understand the philosophy of law, the jurisprudence, analytical jurisprudence, and classical jurisprudence, but as well they gauge our knowledge of law with the social change and social realities. That's why I still submit that we need to go through the schools of thought in a manner that we get to understand the foundation of law as based on different thinkers and those who have delved in it over a long period of time in the past. Thank you. I think you have earned something new in this video presentation. I still look forward to receiving you in other video episodes. University of Nairobi School of Law, Kisumu Campus. I'm Peter. Thank you. Remember to subscribe.